Okay, I think we will get started and welcome everybody. We are thrilled to have you join us today's panel discussion on navigating mental health and substance use treatment leaves in the legal profession. At Lawyers Concern for Lawyers, LCL, we frequently speak about mental health and substance use disorders, raising awareness about signs and symptoms, educating on prevention strategies, and connecting legal professionals with the resources they need. However, sometimes for one to become well, lawyers and other legal professionals need to fully focus on their mental health and recovery and ultimately take a leave of absence from their work. And that's why we're here today, to explore what it means to take a leave, how to navigate the process, and how to successfully return to work. I'm Amy Levine, Director of Programs and Volunteers at LCL. I'll be your host and moderator for the discussion. We know this is a topic that will generate many questions, and we encourage you to submit them through the chat or Q&A function. And while we won't address them immediately, we will make time at the end to get to as many as possible. Now, I am honored to introduce our esteemed panelists. Attorney David Rosenblatt. David is a recently retired attorney and longtime partner at Burns & Levinson, where he practiced for over 4 decades. David also served as managing partner for 24 years before stepping down in April of 2023. Passionate about lawyer well-being, he now serves as treasurer and board member of LCL and 2 other nonprofit boards. Next, attorney Beth Myers. Beth is an experienced employment attorney and one of the founding partners at Zucker Law Group. Previously, Beth was a partner at Burns & Levinson as well. She currently serves on the LCL board, where she is deeply committed to improving mental health and well-being of the legal community. And finally, but certainly not least, Dr. Sean Healy. Sean is the Director of Administrative Operations and a licensed clinical psychologist at LCL. He provides individual consultations, facilitates support groups, and frequently presents on topics including mental health, substance use disorders, neurodivergence, and overall well-being in the legal profession. For more details on our panelists' backgrounds and expertise, I encourage you to read their full bios on our website. And thank you to our panelists for taking the time to be here today. So let's get started. I am going to start with Sean. Why is it important for legal professionals to consider taking a leave of absence when facing mental health or substance use challenges? And what are some common signs that an attorney or legal professional may need to step away from work for their well-being?
Thanks, Amy. Those are 2 great questions. I think it's really important for people to start with an awareness of themselves. This is easier said than done, by all means. But when we're thinking about our mental health, our physical health, our general well-being, it's really important to be taking an occasional litmus test to see, like, how am I doing? How am I responding to the environment that I'm in? One of the reasons why this is so important is because we get used to sort of how we operate in the stressful worlds that we live. And so it can be really easy for us to sort of get used to a level of stress, to get used to a level of distress, or used to a level of unhealthy coping mechanism. And so it becomes sort of like our baseline. And so we can often miss sort of how we're doing, right? We can miss how serious a situation is because we're too close to it. And so maybe I'll sort of go a roundabout way of answering these questions by saying one thing that's really helpful in assessing, like, do I need to take a leave? Do I even need to consider a leave? One of the things that's helpful is to be talking to other people who know you, right? So that self-awareness is important, but it's really helpful to be talking to people who you trust, who know you both in your work setting or in your personal life, because oftentimes those people have a more objective view of how you're doing, right? We can get used to a level of stress that sort of becomes our operating baseline. but somebody else who cares about us can often say like, hey, like you're not doing as well, or I see you struggling in a way that you haven't before. So that insight can be really helpful. One of the reasons why it's helpful to consider a leave is when whatever pattern that you're in terms of the work stress as well as your personal well-being is not sustainable, right? When it gets to a point where looking further into the future, it's not just about getting through, this day or this week or this month, but like, is this sustainable going forward? And am I expecting this level of stress and this level of struggle to persist? And so oftentimes we can go through periods of great distress or pressure and sort of get through it and be like, well, that's what I'm supposed to do. I'm supposed to get through these things. But when we're struggling more and more to get through it, when we're struggling more to get the work done that we have, when we're struggling in other areas of our life, if I can just get work done, but everything else in life is falling apart, those
Mm.
are important things to pay attention to and consider a change, right? Sometimes that change is I need to add supports. Sometimes that change is I need to decrease pressure and stress. And sometimes that is specifically around work and needing to step away for a leave in order to do those things in terms of treatment or supports. And things to pay attention to are, again, like your baseline functioning, right? Am I able to do the things that are important in my life in terms of your personal life, your professional life, right? Are things starting to slip in any of those areas to a significant degree? And again, looking at the sustainability of that pattern, right? So if I am just barely holding on to being able to get work done, or maybe I'm not able to get work done. Maybe I'm just keeping my head above water and watching the things pile up in terms of things that are overdue, or I'm starting to miss things more and more and more, and I don't see that pattern changing. Those are things to pay attention to. So having significant issues with sleep, with motivation, right, with productivity and focus. All of those things are important to pay attention to. They may not all lead to the conclusion of needing to take a leave, but if you're focused on that, if you're attuned to those different areas of functioning, then you're more likely to be able to recognize when I need an added support, either inside or outside of work. When do I might need to consider a leave or a modification or an accommodation? So the more that we're aware leading up to the point of a leave, you have more options, right? It's when we're sort of not aware of our situation and our well-being, when we're sort of not able to consider changing anything. That's when we get to the point of a more of a crisis, and
Mm.
then it's harder to deal with a crisis. But obviously, when we get to that point, it's important to know what to do, how to deal with a crisis, how to ask for, accommodations, support, and facilitate a leave. There's much more to say about that, but I'll pause there.
Okay. And yes, we are going to get to some of those things that you mentioned. And this is a question for David. So, you were a managing partner at one of the top Boston law firms, and you manage the business side of the firm as well as the people. What was important for you and from the management perspective to consider when an attorney approached you about taking a leave of absence? And what do you think is important or not to take a leave from work?
Well, let me answer in a few ways. I was managing partner of my firm for 24 years. I practiced in Boston for over 4 decades, and over that period of time, saw a lot of mental health issues, both in our firm and just in the legal community. And uh, the progression of how we've treated these kinds of problems has advanced, but not to the point where it needs to be. We need to get to the point in our profession where we treat mental health issues and problems in our profession the same that we do physical health problems. And we are not there yet at all. When someone is physically ill, uh, with a serious illness or whatever it may be, we expect them to seek treatment, to leave the firm, hopefully temporarily, if need be, if they can't practice, then to recover and come back to the firm. That is exactly what we should expect with mental health issues in law firms as well. And we are not there yet. We are a long way from that because of stigma and a concern that lawyers have to be strong and powerful, and any mental issues are weaknesses and all the things that go into stigma. So as a general matter, we should be supportive of leaves and generally encourage people when necessary to do it. Another aspect of it, of course, is the business perspective. And as you're running a law firm, you have to be aware of your personnel and who's important in the organization and how you want to keep your people. If someone is really struggling with a mental health issue and they're going to leave the firm, better that you try to work this through a leave where you could get that person back, because every time you lose someone, there's an economic loss, especially if they're a top performer or an important practice area. And in our firm, we've had these situations where we've worked leaves with people who we really needed to come back because of their role in the firm. When you lose someone, to try to replace them, you have headhunter fees, you have a loss of billable hours, you have loss of relationships, you have someone kind of starting from scratch. A lot of times, depending on the area, you can't get someone right away. So from a business perspective, you really want to do whatever you can to keep that person on the roster of the firm. If they need to take some time away to get some help, do that. But again, that's how we treat people with physical ailments. And we have to get to that point in law firms where we're treating people exactly the same way with respect to mental health struggles. And I hope we can get there, and hopefully programs like this and with some of the work that LCL does and others in the community can help us get to that point.
Excellent, excellent. And this is going to be a question, Sean, I'm going to come back to you. Beth, of course, we're going to get to you momentarily. But Sean, how should that lawyer or legal professional then approach their supervisor about taking a leave? And what does that conversation look like? And then, David, I am going to go back to you in terms of what you would want to hear from that employee when they're taking that leave.
Yeah, I think what's important to consider is not only the conversation you'd have with a supervisor, but sort of like the prep work prior to that point, right? So it's important to be talking to mental health professionals, right, to address like what is the most appropriate amount of treatment, what types of treatment would be recommended for substance use, um, what what level of treatment would be recommended, so that you have an understanding of what it is that's going to be helpful, not only in terms of the level of treatment, but also the recovery. So like there is hope in treatment, right? So people can recover from, struggles with depression, anxiety, burnout, stress, substance use, right? There are well-founded and successful treatments for all of these things. And so the more that you know what is needed, that can give you a roadmap in terms of what that treatment and recovery will look like, and also what that'll help you restore in terms of your functioning and your health. And so once you have that picture a little clearer, and then you can also be talking to those mental health professionals. I mean, LCL is another resource to be talking to the clinicians about, like, how do I have this conversation? Like, I've never had this conversation with an employer before. Not only, was it helpful to think about how I would say it, maybe who I would have this conversation with at the firm or the organization, maybe assessing the culture there. To David's point, like some firms are much more open about having these conversations. They might be more knowledgeable, they might have more experience with leaves. Other organizations or firms, less so, right? So there's not one answer that's going to be applicable across the board in terms of what that conversation would look like. So it's important to have an individualized approach. And then sort of planning out what you would say in terms of, what your needs are, what the treatment or what you think or what you've been told sort of that treatment would require in terms of time, and then recovery, reentry back to the workforce, and also how that would help. So, you can look at it from a personal well-being point of view, like what's going to be helpful to me. And then at the same time, you can look at it, as David mentioned, as like the business side of it, right? You working for an organization or a firm, you have shared goals, which is to be successful, productive, and contribute to the health of the organization as well as yours. So trying to connect those things as well can be helpful in that conversation. So it's not just about me and what I need, but also how that affects my colleagues, the work that I'm doing, the health of the organization. Um, and so the more that you can be clear about it, sort of address ahead of time hesitation around stigma or like how much to share,
Mm.
right? These sort of discussions and decisions should be made ahead of time so you feel more comfortable having the conversation. And then if there's some information that you don't need to share, right? Beth will get into more details about what's required or what might be most helpful. Um, but if you've never sort of run through that conversation in your head or with somebody else, that's really hard to know in the moment. How do I have this conversation? So practicing that with a mental health professional, with a friend, the family member, just so that you feel like, oh, this is not the first time I'm having this conversation. And also be paying attention to the feedback that you're getting non-verbally and verbally from the person you're talking to. You sort of pick up a lot of cues about like, oh, is this a receptive person to this issue? Am I getting support? Am I getting, you know, um, negativity or resistance, right? And then having a plan for that as well, right? You want to plan for the worst and hope for the best. And so the more that you feel prepared, you're going to be able to be more resilient in those conversations.
And I'll just add to that, for those more specific conversations, again, and Sean mentioned this, is to contact LCL and speak with a clinician. And you can go over your specific situation. And I think that any of our clinicians can help guide you a little bit more to your specific situation. So thank you so much, Sean. And going back to David, again, from your perspective, again, it's nice that we have you as a previous managing partner. When people are having that conversation with you, what do you expect to hear or want to hear from that person?
Well, you have to start from the standpoint of really looking at this person almost in a heroic sense. I mean, for someone to come forward to a managing partner or an HR director to talk about some of their mental health issues, the amount of courage that that takes is really extraordinary. So you have to start from that standpoint of admiration that the person has gotten things together enough that they feel comfortable, as uncomfortable it probably as it is, but they're coming forward to seek help and to then get the support of the firm. And when that happens, I mean, it's just obvious you have to give it someone to take that step. You then want to inquire and get as much information as you can. They don't have to share everything, and Beth will go over what some of the minimum requirements are to take these leaves. But the more information that the person can share in terms of how long they think it's going to be, in terms of whether they anticipate coming back in a part-time basis, what client relationships need to be carefully managed, what they need. The more they can give you about that, the better. The more detail they can give you about the problem, the better. Obviously, you're going to preserve those confidences, but the more you can kind of work together, because this is a road that's going to go on for a while, and then the reentry process is going to be uh, present some challenges, and you want to kind of work hand in hand with the person. So when someone comes to you with courage, with honesty, with healing on their minds and the need to get this part of their life together, you just have to be applauding, sympathetic, encouraging, supporting. And those are the situations, in my experience, that have worked out pretty well. We've had some good experiences in our firm with people who did just that.
Excellent, excellent, and definitely appreciate that, hearing that from you. Beth, we are getting to you. And since you are an employment attorney, I think you do bring a different perspective. So, what thoughts do you have about having this conversation with the law firm or legal employer? And what should that employee think about when having this conversation? Who should they talk to first, and how much should they share?
Yeah, well, listening to David, I feel like I have been a bit jaded, given what I'm exposed to and who I talk to, because I think, in the ideal world, an employer would respond the way that David has described, and there are certainly employers out there that respond that way. I just don't hear from those employees. Um, I think that one thing that's very true, anytime there's any kind of medical issue, mental health issue, or disability question, anytime there's sort of like an employment law topic that's triggered, is it can make people uncomfortable. It can make people uncomfortable because they're afraid they're going to do the wrong thing or say the wrong thing. That they may have a heightened awareness that the employer has some, additional obligations. They're aware generally that you can't discriminate against someone. And so I think one thing to remember is that, if you're thinking of approaching a supervisor, a boss, HR, it's going to be maybe not equally uncomfortable, but it's going to be uncomfortable and a bit stressful for the other person too, because unless they have a ton of warning and really kind of understand what you're coming to them for ahead of time, you may catch them off guard. You may be providing information to them that's completely new and shocking. It may not be new. They may have been waiting for you to come and address some issues you've been having. But I just think you have to try and remember that on a human level, people are imperfect, and for the most part, I want to believe they try and do the right thing. But as Sean said, I think you do want to prepare for the not for the worst, but maybe for the conversation to be challenging. I think you have to use your EQ and your existing relationships with the employer, as you approach that conversation. And if they have been, supportive and empathetic, I would hope there's a decent chance that's going to be their reaction. If that's not been your experience, I think you probably want to be more guarded. Things to think about. When you are thinking about taking a leave, you do not have to tell your boss or the partner you work with anything about the reason for the leave. You can. That is completely up to the employee, how much they disclose. But other than this employee is going out on medical leave, HR or the benefits folks do not and should not share any further information with the people that you work with unless you allow them to. So in thinking about, is this something that you feel comfortable or you're willing to share with some of your colleagues or with your supervisor? If you are not sure, or if you are sure you are not comfortable sharing it, then going to HR would be my advice. And you can say to HR, I haven't disclosed this to anyone I work with or to my boss, and I'd rather right now keep it confidential. It can certainly be awkward for people that worked closely with you to know that you are taking a leave or you are absent from work for periods of time and they know nothing about it. But it's also your right to maintain that level of privacy. I would be forthcoming about your privacy concerns, because I think sometimes, again, people are human and they make mistakes. So if it's important for you to maintain privacy around the reason for your leave, I would say that more than once. If you work in a place where you feel comfortable disclosing that it's mental health related, you don't have to say anything more than that. So really how much you say and what you say is up to you. I do want to draw a distinction between mental health and substance use, substance abuse, with alcoholism. Under our employment laws, there are certain mental health, well, pretty much all mental health conditions that rise to a certain level are covered and are considered disabilities and protected. Substance use is a little different. So alcoholism is a protected disability under both our state and federal laws. any kind of use or abuse of illicit drugs is not. And so if you are struggling with use or abuse of an illicit drug, or even, misuse of a prescribed medication, my advice would be don't disclose that. You do not need to disclose the specifics. If you share that you are struggling with, a cocaine addiction, that can end up getting messy. So if you're choosing to share that it's substance use related, I would leave it at that. And just be mindful of the fact that at the end of the day, addiction related to illicit substances is not yet protected under our laws. I'm just looking at my notes here. I also think the reality, and this is a little bit goes back to what Sean was saying at the beginning, is that I think as lawyers, some of us, in addition to not maybe being all that self-aware as our stress level or as our kind of incapacity grows, we may get to kind of a crisis level before we are motivated to say something or do something about it. I also think that we tend to think that we are maybe more important than we are. And so when discussing, kind of how you're doing with your trusted people, if you have trusted people who are in the legal profession, I would also advise that you talk to them, because those are the folks that can remind you that the law firm will go on without you. The world will not come to, a crushing halt if you take time off of work. It may feel that way. I'm not saying that I practice what I preach, but I'm just saying that the idea of taking a leave may be completely foreign. And it may be that you end up approaching HR or the managing partner saying, I'm really struggling, here's what's going on. I'm having trouble focusing. I'm, distracted. I'm crying all the time. And it may be someone else who says, maybe you could take a leave. I'll get into the kind of options and specifics in a moment. But it would be ideal if you could see it coming, address it before it's a crisis. But that's not always how it happens. And so sometimes you're informing your employer from the ER after you've had some sort of crisis. Sometimes you have been, you've checked into a treatment facility, whether it's inpatient or outpatient, and you're sort of trying to work it out after the fact. Employers love as much advance notice as you can provide. The law also encourages providing as much notice as possible, but there are circumstances where providing advance notice is just not an option. And so you're going to have to work with what you've got. But I would be careful. I think, personally, I advocate against, being fearful of sharing that what you're struggling with is a mental health condition or substance use, because I think it's important to helping minimize and end the stigma to share that kind of thing. But it's also very different to sit in front of your colleagues and leadership at your firm and say that in your history or you in your past have experienced a mental health crisis and you got help and you dealt with it, and here you are, either continuing to receive help or treatment or having kind of recovered from it and put it behind you, from disclosing that in this moment, I am incapacitated by mental health or substance use. And I just think you have to be mindful about what you're sharing and when you're sharing.
So thank you, by the way, all of you, for talking about what that conversation could and could not look like. And I'm going to change the topic a little bit so we get some more concrete facts. So Beth, can you talk a little bit more about what an employee's rights and protections look like? Keeping in mind, we do have folks in the audience who maybe are solo practitioners, others who work at small to mid-sized firms, and that some are at very large firms. So I think you might have a PowerPoint presentation.
I do have a PowerPoint, and I apologize in advance because I am not a PowerPoint designer. It is not in my skill set. And I also am encouraging and reminding my fellow panelists to feel free to hurry me along if this starts taking too long. But give me one moment and I will. I'm also shifting around in my chair a lot, and I apologize if that is distracting, but I took a small tumble down the stairs in my house a couple weeks ago and managed to break my tailbone. So I am uncomfortable. But okay, I found it. All right, I'm gonna put this on slideshow. Okay, so very quickly, up until a few years ago, if you were going to take any kind of leave from work beyond just using your sick days, the only protected means to take leave, meaning your job had to be preserved and you couldn't get fired for taking extended time off, was if your employer was covered by the federal FMLA, Family Medical Leave Act. And in order to be covered, it had to be a certain size. It had to have at least 15 employees. There was some geographic requirements. And so, at the end of the day, not everyone was covered by FMLA. And even if you were, it didn't provide any benefits. It protected your job so that you could take leave and leave your job to focus on caring for a family member or yourself, but without any pay. Which is of limited value if you don't have extra funds laying around. So a few years ago, Massachusetts, after many, many years of trying, passed the Paid Family Medical Leave Act. And what the Paid Family Medical Leave Act does is it provides protected leave for medical conditions to care for yourself and address a medical or mental health condition, or also caring for a family. I'm not going to get into the parental leave, caring for a family member, because that's not the focus of today, but it provides leave. It also provides the payment of benefits during that leave, which is a very unique feature. Not many states do this. There's nothing on a federal level that provides for this kind of benefit. So let me just kind of bang through eligibility. You have to have a serious health condition that prevents you from working. That includes a mental health condition. There are some financial eligibility requirements, which are somewhat modest. You have to have earned, $5,700 in the last, I think, 24 weeks within the last year. That's a lot lower bar than FMLA. You can be eligible day one of your job. And for the most part, many private employers and public employers are covered by PFML. If you are a solo or in a small firm, and this is on a later slide, you can participate by making contributions. So something to know, it's not completely exclusive to larger employers. Okay, so a serious health condition includes illness, injury, impairment, physical or mental, and it requires ongoing treatment. It also requires certification by a healthcare provider. And the statute and the information online gives some more details. You can require inpatient care. There could be some level of continuing treatment, and you can show a complete incapacity. I think the bottom line is, if you're sick enough, either physically or mentally, to be out of work for 3 consecutive days, and you're going to require a couple appointments for follow-up to treat whatever it is, that qualifies. I almost never deal with pushback from the employer or from the state that it's not a qualifying health condition. If your provider says this is incapacitating, you require ongoing treatment, and there's some evidence of that, it's usually enough. So I wouldn't spend too much time worrying about, can you demonstrate a serious health condition? There's a list of kinds of providers that PFML will accept. I mean, the other thing to keep in mind here is that this is a decision made by the state, not your employer. So your employer has nothing to do with determining whether you are sufficiently incapacitated or whether the reason for your leave is, enough or anything like that. These forms go to the state, they make the decision. I've had therapists, certify drug and alcohol counselors, certainly psychologists, psychiatrists, nurse practitioners that prescribe. As I said before, ideally provide advance notice. So if you're self-employed or you're 1099, you have to opt in to be covered by PFMLA, and then you'd pay quarterly contributions. because employees and employers are paying percent with each pay period. So if you're doing quarterly estimated taxes, you'd also be making quarterly contributions. Okay, so one thing to think about, I think, when we talk about leave is that it's not just a continuous leave. It doesn't have to be 2 weeks of leave or a month of leave or 3 months of leave. The PFML allows for up to 20 weeks, which is longer than the FMLA. Under FMLA, you would only get 12 weeks. So there's additional time here that you can take off. But if you don't need a full block of time, you don't have to take a full block of time. So if a reduced schedule would be helpful. If you need an initial period of continuous leave to participate in some sort of inpatient treatment program, and then after that, you're going to have some ongoing support through an outpatient program, you might be able to work in the mornings, but not the afternoons, or you might be able to work a few days a week. And that can be part of your PFML leave. So think through, whether a continuous leave, and you can talk to your, providers. Obviously, different types of leave present different obstacles and challenges for an employer. The reality is that someone going out on a leave is very difficult for an employer to deal with. Even a large employer, it creates it's a burden, and that is not unlawful. It's not unlawful for an employer to feel burdened or to have additional challenges in staffing and covering the work. When it becomes a problem is when there's actions taken that interfere with your ability to take that leave, or obviously retaliate against you for taking that leave. But it can be challenging, and your colleagues also are going to have to pick up the slack. So I think you also want to be mindful of just the human relation component, that not everyone has to be thrilled that you're going to be absent and they have to kind of step in for you, but they are obligated to do that. Sometimes a continuous leave can be easier for an employer to deal with than an intermittent leave, which is like, I'm going to be if this flares up, I might need to take the day off, or I might need to take 3 days off. That's difficult for an employer to deal with, but also it is an entitlement and it's an option under the statute. So the wages and the compensation that you receive is similar, although not identical, in how it's calculated to unemployment. There is an online calculator, which I have a link to at the end of this, but it's typically between 65 to 80% of your regular wages, and there's a cap at 1,084. The first week of a PFML leave is unpaid, so you want to use your PTO or your sick time.
So can I ask a quick question, Beth? So
Yes.
in order for somebody to get that money, they apply through the state. Is that correct, as opposed to their employer?
Yeah, your employer may provide the forms to you, and it also depends on what other benefits you have available. So if you work for an employer that provides a short-term disability policy, you're going to be dealing with them and the carrier for the policy, whether it's the carrier that provides the forms to you or whether it's the employer. So there are times when they would provide you with the form, or maybe information to find it online. But with respect to the PFMLA form, you would fill it out, your physician or your therapist fills it out, and then you submit it to the state. You can take advantage of both PFML and short-term disability. There's a way that you can kind of have your disability benefits top off so that you're getting as close to, if not to 100% of your wages. Many short-term disability carriers will require that you apply for PFML and will use it as an offset for your short-term disability benefits. But the two work together. And then at the end of the leave, if you're looking to extend it, you can also use accrued vacation or PTO. And we can talk more about requesting an accommodation upon your return, whether that's in the form of a bit of an extended leave or whether that's in the form of a reduced schedule as you come back. One thing that's unique about the PFML is there's language in there that creates not a resumption, but a presumption of retaliation. If there is any adverse action taken against you during your leave or within 6 months following the leave. So, if you're back from your leave for a couple months and you find yourself demoted for reasons that don't really make sense, the employer will have a burden, a heightened burden, to demonstrate why it's not retaliation and why it's unrelated to your leave. And there's some language in the regulations that talk about retaliating and interfering and discriminating. Here are some helpful resources. The first link just is kind of a general website for employees who are seeking to learn about PFML. The second one is the actual form that you would need to fill out, and your physician or provider would also need to fill out. And then there's a benefit calculator online. So this is available to anyone participating. And I encourage you to go to the website and just kind of look around it. They do have a lot of helpful information. So let me see here. Yeah, so there's no size, there's no employee numerosity requirement. So, if you work for a law firm that has 3 employees, you are still probably covered. Again, if a lawyer in a 3-lawyer law firm goes out on leave, that is a very different thing to deal with than a 50 attorney practice group within a massive law firm. And so my biggest piece of advice during a leave, leading up to a leave, is communicate, over communicate. I'm not saying that you need to share more information than you're comfortable sharing about what's going on with you, but in terms of, we should have more information about when my expected return can be after next week's appointment, or my physician thinks that it's likely within X number of weeks that I'll be able to come back in a reduced capacity, but we'll check in. We're going to be checking in on every 2 weeks, and I'll update you after those. There isn't any set calendar obligating an employee to update the employer on a certain schedule, but the employer can ask for updates. The employer can check in. It can feel really intrusive, which is another reason why I suggest just communicating it before you're asked. But if you can kind of keep them in the loop and make it so that they don't feel like you're just kind of floating out there in this unknown and they don't know, when you're coming back, if you're coming back, it can really help with the reentry. And it is very common for someone to not know the answer of when will you be able to come back and what will that look like. But if you don't know the answer and you say, well, here's what we think and here's what I'm hoping, I'm hoping to be well enough to return within X number of weeks or within X number of months, or when my leave is over, I will be looking to come back. I may need a reduced schedule at that point. And I don't know what that looks like, but as soon as I know more, I'm going to share it with you. So, my advice is over communicate. It can avoid all sorts of kind of messy things that happen when people feel like they don't know what's going on. But again, throughout the course of your leave, if you're, seeking treatment for because you had a suicide attempt, or you are suffering from a kind of flare up of a pre-existing mental health condition that you don't feel like disclosing, you don't have to disclose it. The forms, like I said, will go to the state. There may be forms that go through your employer via a benefits person or HR. Beyond that, no one has a right to see or know anything about what's going on. That's up to you and what you share.
This is excellent information, and I think very valuable, especially about being paid, because I think that is something that sometimes prevents somebody from taking that leave because of finances. I do want to point out those slides are going to be available on our website, and when the presentation is over and you get the recording, the slides will accompany that. So just for those that want to read a little bit more. And I'm also just going to take another opportunity to perhaps plug LCL, where I think a part of this, and you talk about solo practitioners, and you do have something urgent that comes up and you need to take the leave, you want to have a succession plan in place. It's not just when you're closing down a practice. You want to have, and it's good to start for any solo practitioner at this point. And you can talk to one of our advisors on how to do that, but a plan where your clients and cases could go. So again, please contact our senior law advisor for more guidance on that, for making that succession plan. Again, great information, Beth. Thank you so much. I am going to now talk about returning to work after your leave. So returning after that mental health or substance use leave can be daunting, and many attorneys struggle with self-doubt, imposter syndrome, or fears about the competence, just to name a few. So now we're going to go to Sean. And can you talk a little bit about these struggles and other challenges attorneys may face when returning from a leave? And if you also want to mention how you might talk to colleagues about why you were out.
Yeah, absolutely. So I just want to acknowledge that even though, like to one of David's earlier points, even though mental health and substance use should be treated and viewed like a physical health issue, there's still stigma that impacts how we view a mental health struggle versus a physical ailment. So just want to acknowledge that. It doesn't mean that that is, you know, going to be the case always, but that makes it a little more challenging often when returning to work or discussing sort of a return after a leave. To Beth's point, like you can decide what you disclose. And in terms of communicating to colleagues and supervisors, I think it's helpful for you to sort of be aware of what you're comfortable with, right? So basically assess your own level of stigma, right? That you might hold about, the issues that you've dealt with and got treatment for. I highly recommend talking to the extent that you can, talking to other people who have been through that process. So for example, if you've gone to a treatment program, right? If there's other people within that treatment program or counselors at that treatment program that can sort of talk to you about their experiences of being on a leave, returning to work. If you know people at your organization or firm that have gone on a leave and returned, the more that you can sort of have insight or a conversation about how somebody has done it or what to expect, that can be a little helpful. And also considering like what you want people to know, um, what you want, to Beth's earlier point, like if you want things kept in confidence, like state that repeatedly, right? So if you have trusted colleagues, but you don't want everybody to know all the details, and you want to share, some details with trusted colleagues, make sure that you're being explicit about what you're asking them to hold confidential. Um, it's also on a personal level helpful for you to feel comfortable that you feel like I can talk about this, even for myself, I can talk about this as a story of resilience, right? Like I recognized a need, I recognized helpful support or treatment. And now because of that, I am stronger as a person, as a professional, and now I'm re-entering that role again. So the more that you feel confident in that, the more that you feel like that's a story that you can tell yourself and tell other people, that makes those conversations a little bit easier. You're never going to be able to control how someone hears that story, but the more that you feel that confidence, or at the very least, can portray that confidence at first, because sometimes it's just uh, when you're having that conversation for the first time, it can feel vulnerable. It can feel scary. And so sometimes, that old adage of fake it till you make it, that isn't a recommendation to fool other people that you have it together when you really don't. That message, that old adage, is about you doing something before you feel like you can do it, and then your feelings catch up with you. So for example, I don't feel like I can have this conversation with my colleague, but I can pretend like I'm having this conversation, or I can pretend that I'm confident in having this conversation. And then after the conversation happens, then my feelings start to catch up with me, right? So that now mid conversation, or maybe after the conversation, I remind myself I actually did it. Even though I didn't feel like I could do it, I actually did it. And therefore, I might now feel more comfortable to have the next conversation. So I think it's important to sort of distinguish like what that whole adage or recommendation is about. It's not about fooling people. It's about helping yourself sort of do something that seems scary and then watching your feelings or your confidence catch up with you eventually. So again, to repeat what Beth has said, be thoughtful about what it is that you want people to know. What do you think is helpful for people to know? Who do you feel comfortable sharing that with in terms of your colleagues? In terms of re-entry, hopefully prior to re-entry, you've had conversations around modified schedules or supports that would be helpful. That's another thing to be thinking about in terms of accommodations or supports. Like when you can connect that to, not only is this good for me, but it's also good for how I'm able to do my work, right? It's not just this. Sometimes we think about accommodations as like, oh, it's something special for this one person that nobody else gets, right? That's a negative sort of look at accommodations. My preferred view on accommodations is like we all have accommodations. These are the things that help us do our best. And so if we can identify something that's helpful, even if it's new, and connect that to like me doing well and doing my work well and the wellness of the organization or the firm, like that's an easier way to talk about accommodations and reentry, whether that's a modified schedule, right? Or something specific in terms of a support. And then again, just to reiterate what Beth said, like the more explicit you can be, the better, just because with the ambiguity, that's usually where either confusion grows, anxiety grows on the part of the supervisor or the firm. Like if they don't know anything, that's, great space for concern and anxiety to grow. But the extent that you have knowledge about how to make things explicit or sharing information that can clarify something, that can be helpful in terms both for yourself and for your supervisors.
Amy, can I jump in
Excellent.
really quickly and just
Absolutely.
address I see there's a question in the chat, and there's also something that I just wanted to mention before and I didn't. Number one, PFML benefits are not tied to your active employment. So it's not something that you have to be actively employed in order to be eligible for. It has this requirement, this look back of the last 12 months if you've earned $5,700 in income. So if you left a job voluntarily, or if you were fired because of performance issues, and then, within the next few weeks or something, you decide this is actually related to a mental health condition and I am not able to work, so I can't collect unemployment because I can't certify that I'm looking and able to work, you can apply for PFML benefits. It's obviously not going to protect your job because you're not working, but it will provide you with benefits. Someone asked if these benefits can be retroactive. Yes, if you apply for benefits within 90 days of the start of a leave. So if you took a month off of work and your employer just, supported it and didn't, want any medical certification or anything, you could apply retroactive, but it needs to be within 90 days of the start of the leave. And lastly, your leave year is not a calendar year. It's a little complicated. I think it's like from the Sunday following the first day of your leave, but essentially it is around a week from when you took leave, because of that 1 week no benefit period. I think it's the week before you started leave, paid benefits, is when your year starts. So a year from a week before your leave started is a whole new year. So you could take additional benefits, in the following year, another 20 weeks, essentially. You don't have to use up the full 20 weeks, but if you needed additional leave, and your employer wasn't able to provide you with additional leave, you would have a right to protected leave once that new year benefit period kicked in.
Somebody else is asking specifically, does the state pay for
the
leave
state.
or employee? What about short-term
So
disability?
you pay for it. If you look at your pay stub, you'll see starting a few years ago, there was a little PFML deduction that happened. So, if you're in a covered employment situation, it's deducted, you're paying into the system. Short-term disability is entirely different. Those are private policies. Some employers provide them. Other folks go out and purchase an individual short-term disability policy. They're expensive. Someone asked a question about benefits for solos. They are expensive. There are options for short-term disability plans for solos and small firms. But that is a private plan that you would purchase. You'd have to apply for and enroll in it. If your employer offers it and you enrolled in that, also that would show up if you have like a long-term disability, that would show up. Some employers are self-insured for short-term disability, so it wouldn't necessarily show up on your pay stub. But if you have questions or you're unsure whether you're covered by a short-term disability policy, your HR department will know, and that provides benefits in addition to PFML. So a little different, a little complicated.
And I just, and Beth, you've said this, but I think, yes, a few years ago, if people look at their paycheck, you are having money deducted. Every person is having money deducted from their pay stub if they're, I guess, at a private firm. So essentially, right, we're all paying for that. I am going to change the topic. Again, I know we do have some more specific employment questions, but I do want to get to a few other pieces of this puzzle. And this is for Beth and David. What should an attorney say or not say to their clients about their time out of the office? So it's a little bit different than these conversations with your employer. What does that look like?
Well, David, I know that we had a number of leaves at the firm over the years, and I'm curious to hear what those conversations were like, either with the practice group chairs or with the attorney themselves, around what you would tell clients about the attorney's absence.
Yeah, I mean, it would really depends on the client relationship. If it's a partner and they have a close relationship with a client, and a lot of lawyers do with their clients, and you feel comfortable sharing, you should, there's no problem sharing, especially if it's a longstanding close relationship. I think if it's an associate or more junior lawyer who doesn't have the top of the client relationship, you don't really need to say much of anything. Person is just out or is, gone for a while or something. I mean, you don't really need to say much. So I think if you're really going to talk to a client about what specifically has happened here, it should be a situation where the lawyer has a pretty close relationship with the client to begin with, and the client would be understanding and supportive, and hopefully stay with the firm, and there'd be other people that would pick up the ball. We've had situations like that. And the same is true with medical leave. Again, I'm trying to get to the point where
Right.
medical leave and mental health leave are essentially treated the same. That happens all the time. It's an easier conversation because of stigma and all the other things that we've talked about. But you want to, get to that point where mental health leaves and medical leaves can be treated similarly. We're not there yet. But there certainly would be situations where there are close client relationships where a lawyer, if he or she felt comfortable talking to the client about it, could do so.
Yeah,
Makes
I'm hesitant to advise people, what to share and what not to share. But in general, I am much more comfortable suggesting that people share a level of detail around a mental health or substance use abuse issue kind of after the fact rather than when they are in it. Because I think in addition to stigma, I think there can also be some potentially legitimate concern from the employer or from the client around, is this going to affect this person's capacity to handle my matter or be an employee? And so, there are folks that would feel very comfortable sharing what they're struggling with, and would leave it to whether it's the employer or the client to have whatever reaction they're going to have, and be sort of divorced from that reaction. But then, I also think like I said, there's a difference between saying, remember when I was absent last year for a couple weeks or for whatever, I was getting some help for depression. But then you've been back working on the matter. The client may say, oh gosh, wow, okay, well, good for you. Instead of, oh God, you're hospitalized in this moment and you're going to come back and start working on my thing again. And what is that going to look like? So I also just encourage you to think about timing, right? You don't just because something's on your chest and you're feeling a lot of feelings about it, and you don't want to be dishonest, and you do want to kind of work towards ending the stigma. That doesn't mean that you have to share it while you're going through it. There's plenty of opportunity to share kind of as you are in a more kind of recovery mode. However, to each his own. The other thing that I think is important to realize is that before you return from a medical leave of any kind, your employer could and should ask for essentially a doctor's note or something clearing you to return for work. Without that, it can be a liability. But something that happens sometimes is that an employer may have concerns about your capacity and what this means for your ability to come back to work. And that's not their call. So if a medical professional or your therapist or whomever clears you, this person is cleared to return to work full-time, no restrictions. This person is cleared to return to work, on a 20-hour-a-week schedule, whatever. If the provider is saying that, the employer cannot say, well, but you've been out for, because of a flare up in your schizophrenia, and how can we feel safe that you're not going to have some sort of episode that freaks people out in the office? Nope. If the medical professional clears you, you get to come back. The employer doesn't get to make that call.
I just want to jump in on that, Beth, because I think that's a good point. One of the points of ignorance, I think, in the legal profession is that with respect to mental health problems and illnesses, people recover. People recover quite often, and there are treatments, and there are all kinds of treatments. And just like people recover from cancer and heart disease and all the other things that people recover from every day, the same happens with mental health issues. And we are ignorant of that often, and especially in law firm management. And so, what you say, there's a note from a medical professional clearing a person. That's it. It's no more suspect to going back into active illness from remission than cancer or heart disease or anything else. And we need to get to that point as we evaluate these situations.
So David, that actually leads me into the next question is, what can a firm do to educate, to create a supportive environment for when somebody does return?
Well, of course, the first question is whether who in the firm knows about this and who should know about this. So it may be a very quiet, private situation. I want to talk about one example, one thing that we did at our firm that was truly an extraordinary moment. We had a few years ago a Zoom when on mental health recovery and illness in the firm, and we found 6 B&L employees. So a few partners, some people at a very high staff level, a couple of associates who were comfortable in a Zoom. We had 60, 70 people talking about their history with mental health issues and their recovery and what they did and how they approached it. And it was heart-rending. It was emotional. It was probably the most important thing we did to advance mental health awareness and a degree of normalcy in the firm that we could have possibly done. So I guess I would say if any firm can get to that point where you find some very brave people who will come forward and be leaders as examples to others who are struggling, that can really go a long, long way. I was very, very proud of that moment. That's one thing.
And I mean, I think on an individual level too, if your firm leadership isn't taking the opportunity to do something like that. And I have to mention that I think one of the people that was responsible for that critical conversation series might be a participant in today's panel. But individuals in a firm, I think, and this is where, I would call on my fellow partners and attorneys who are established and have some level of job security, either through their relationships or in that they're a partner, and have some experience with recovery around mental health or addiction or alcoholism, to disclose that when it's appropriate, whether it's in a public forum within your firm or whether it's on a private basis. I participated in that panel, that internal panel, and disclosed that I was in recovery from alcoholism. That happened. I stopped drinking and became involved in the recovery community 20 years ago. So it wasn't like I was saying, keep an eye out for me. I was just stumbling in the door last week. So it was a much more comfortable place for me to be in to share that. But those of us that participated, we did that because we wanted others to know that this isn't just the law firm saying, you might need help and you can come talk to HR, or there's an EAP program. But we had a staff member who wanted to participate in case other staff members didn't feel comfortable coming to HR or to an attorney. And other partners participated who had dealt with mental health related medical leaves. But for the most part, most people in the firm didn't know that. They just knew this person had been there. Maybe they didn't even notice that they weren't there because we were in this kind of hybrid work experience, and that they were, a respected practitioner within the firm. And then you think, oh gosh, this person says they were crying every day and became, unable to function and had to take a medical leave. And look, they're back, and the firm welcomed them back. And it was really powerful. So even if the workplace isn't organizing something like that, I would encourage you, if you have some experience, or if someone in your family has experience that you can share, that makes you a safe person to come to. Because going to HR, going to a boss, that can be scary. Going to a colleague who has been through it is still scary, but maybe less scary.
But if I could just jump in with one other little story that happened a couple of years ago. And this kind of goes to the theme of, from a firm management perspective, to kind of look more broadly about mental health leaves. We had an associate a very valuable senior associate, who announced that he was going to leave the firm, and didn't give any reason. He just said, I'm leaving. And then the questions came from his supervisor. Well, where are you going? What firm are you going? This does happen, obviously. And it turns out he wasn't going anywhere. He finally got to the point where he was comfortable enough to say, I am so burnt out from what I've been doing year after year. I need a break. I'm just going to stop working. That's the only thing that I can think I can do. And he clearly was suffering from burnout, which is a very common syndrome, occupational syndrome in Massachusetts. The NORC study that LCL commissioned a couple of years ago, that's probably on the LCL website, found that something like 77% of Massachusetts lawyers were suffering from some form of burnout, which is characterized by feelings of depletion, exhaustion, disillusionment with work, and a bunch of other things. So when we talked to him, we said, well, look, what if you took a leave? And what if we set a target for you to try to get better, to refresh yourself and come back? And we worked out some financial terms. It wasn't a formal PFLMA leave, but it was a leave, and it was a mental health leave. And after 4 months, we were kind of looking at the dates to see if he was going to come back. He came back, and he was better than ever. And he resumed his excellent standing in the firm. So these situations can happen. You have to kind of look for them, and I hope more of us can do that.
And just to add one thought, in addition to programs where people sort of share their personal experiences of recovery and resilience, those are amazing. Also be thinking about providing education and training to your staff, firm-wide or organization-wide, around mental health first aid or mental health awareness, just to get that conversation sort of more out into the culture of the organization, so that stigma can can start to be decreased, and people can get a little more comfortable having conversations, right? Noticing, a colleague struggling, just checking in, right? That those little things can start to change the culture and to change the stigma, and sort of provide people with positive messages about asking for help, asking for support, long before, they might need a leave, but also helping facilitate those options as well.
And Sean, actually, I was going to mention for folks, we actually, LCL does a mental health first aid presentation that is offered 4 times a year. So if people, I'm not quite sure the next one, but if people want to look at our website and be aware of the next presentation, it's a limit of 30 people, but again, it's offered 4 times a year. The other thing I want to say, David, kudos for sharing that story and doing what you did for that particular employee, and also hearing that program that you had where people from within the firm were able to share their stories. This is something also I'll mention is that LCL does have volunteers that are open to going into law firms to share their story. Now, granted, it's not somebody from within that same firm, but when attorneys hear other attorneys, whether it's from a similar size firm, smaller firm, larger firm, I think that still helps them relate. And I think it still helps with that stigma. So that's something folks can call LCL and me in particular to get that scheduled. I see that we want to leave some time for Q&A, but before we move to that part of the program, anything else, Sean, Beth, or David, that you want to mention that we haven't mentioned? I thank you all. I mean, very thorough, I think very educational. This was absolutely wonderful hearing from everybody. So let me look at some questions. We were able to answer some of these. FWIW, we can treat them the same. We only tell clients that their attorney is out on medical leave, whether it's mental or physical. So that was one.
That's Jackson
comment.
Lewis.
Yeah.
One thing I will say that we've sort of talked a little bit about, but not directly, is that, when your leave is up, whether you're whether you're exhausting the full 20 weeks or whether you've taken, 2 or 3 weeks and you're planning to return to work, you don't have to return to work full time the next day, the next business day. It is entirely reasonable to ease back in. I would suggest doing that in most cases. And you can request an accommodation. Technically, it would be an accommodation that your employer would either grant or deny, or maybe they would suggest a modified accommodation. But going back to work, working fewer hours every day, working, 3 days a week initially for the first few weeks, something like that, you can certainly request accommodation. I think going back to work that first day, that first week is the hardest. It's scary because, completely separate from how your employer is going to respond. It's scary because you've been out of work and you've been focusing only on wellness, and it's scary to turn and kind of let the rest of your life and the world back in. And so doing so on a reduced basis. I also think, returning to work on like a Wednesday instead of a Monday, that simple decision can, okay, I can do this for 3 days, but you show up on a Monday, and you have the regular, doom spiraling that we all get on a Sunday night, plus the fact that you're coming back from a, multi-month medical leave. That's going to be a pretty daunting week. So, I would just talk to your provider, be realistic. And again, this is where communicating with your employer is crucial, because if your employer thinks that you're coming back to work on Monday and they hear from you over the weekend with a letter from your doctor saying she's cleared to come back to work on a reduced schedule, working 2 days a week, that's information that would have been really helpful for them to have, a few weeks earlier, or even just a week earlier, if that was something that you could provide. So the earlier that you can notify your employer about requested accommodation, they're not obligated, employers are not required to grant the specific accommodation that you request, but they are required to engage in what's called an interactive process. And if they deny an accommodation, they would have to demonstrate that giving you that accommodation would be an undue burden on them. So it depends on the nature of the work, the nature of the employment, the size of the employer. Coming back on a part-time basis, if you work at a 150 lawyer law firm, would be different than coming back to work on a part-time basis if you work at a 3 lawyer law firm. But it's certainly worth thinking about and talking about, both with your treating team, the people that know you, and your employer. So that's something to think about. You can also ask for extended leave if you are not quite ready to come back. An open-ended, I don't know when, but sometime in the future I will be coming back, is not something that an employer is obligated to grant. But if you've exhausted the 20 weeks and you think you need another week, another 3 weeks, you can request that. And in many situations, a reasonable, defined extension of a medical leave can be found as an accommodation that would then be required and protected.
We do have a question that I want to read. I know, Beth, you answered this, so I don't know if you want to answer this live, if you want me to read your answer. But somebody said many solo attorneys are reluctant to get help for their mental health or substance use disorders because they can't leave their cases. Is there any docket support to allow lawyers to use the PFML benefits?
So yes and no. There is a program that I believe went live in the courts, where you can take essentially a medical leave and have that noted in the court system, so that your active cases that are pending in court in Massachusetts would essentially be paused, and you wouldn't be penalized, your clients wouldn't be penalized if you need to step away. That is of limited value, because many attorneys represent clients that aren't litigating matters in court. So this is a hard question, because if you can pay for a private short-term disability policy that would provide you with compensation if you're unable to work. You would be eligible for PFML if you were contributing into the program and you had enrolled within, I think it was 6 months before the leave needs to start. But that doesn't help you with someone stepping in and helping to manage your cases and your clients. This is separate from PFML or any kind of benefit, but having been in a small firm, having been essentially a solo, what I think can be the most useful is to become active in a local bar association or affinity bar association, and network, team up with other solos and small firms, so that if someone needs to be away for any kind of leave, you have someone that you can say, listen, I'm going to be away. I'm not going to be able to, deal with your matter. But if there's truly an emergency, you should reach out to this person. Because I think that's really one of the only ways to ensure that you can have coverage. The reality is that you're really just going to have to put things on the shelf and focus on yourself, even if it is to the detriment of your clients. They can find another attorney. If that's what needs to happen. This goes back to we are not actually the center of the universe. And although it could be quite inconvenient for many people, if you suddenly disappeared, the world would not stop. And so I think, LCL would be a great place to reach out to. The SJC Lawyer Wellbeing Committee was involved and behind some of this court-related leave. And frankly, off the top of my head, I don't know much about it, but I assume that if you reached out to LCL or the SJC Lawyer Wellbeing Committee, both would be able to tell you more about that. But at the end of the day, being a solo or in a small firm is just really challenging because of the lack of support and infrastructure. And so you have to get creative.
Yeah. And just to build off of that, so the SJC Wellbeing Committee has a working group, a secured leave working group, and they're working to develop a similar policy that other states have, sort of like guaranteeing that secured leave. We don't have that fully developed here in Massachusetts yet, but that's sort of in progress. And one of the exceptions in some of the other states is if your clients would be harmed by that leave, or postponing their hearing, then that probably wouldn't be granted. So in criminal law, in criminal cases, there's going to be some barriers there. So all more to bolster Beth's point about having other attorneys that can be helpful in stepping in, taking matters for you, so that if there's an emergency, if you need to step away, if you need to be in treatment for an extended period of time, that even though you're a solo or in a small firm, you have other supports, you have a network where you can sort of get that immediate need met and not have to rely on like a particular judge granting a motion or an extension when in fact you might really need it. So
Essentially, it is plan now for that, because you don't know what the future might hold. And if you end up in that situation, or medical leave, it essentially one and the same. So it is starting to plan now. And again, I'm going to promote our senior advisor on law practice management, and you can talk about more specifics if you're interested in starting that plan. It doesn't look like we have any additional questions. So again, any final thoughts from our panelists?
Just
Before we close out?
one thought
Yeah.
for me, and this is just sort of an overarching thought from a firm management perspective. The assets in a law firm are its people. That's it. The balance sheet might have some computers and some software and some furniture and other stuff, but the assets are its people. The people, they get in the elevator at the end of the day, you hope they come back the next day, and that's it. That's what runs the show. And taking care of your primary assets, your people, that's what it's all about. And that's what mental health leaves, and taking care of each other and the mental health of each other and supporting each other is all about. So it's all part and parcel of caring for the whole organization by caring for each other. And I hope that we can do more of that.
Well, thank you all so much. Valuable information, important information, and hopefully folks watching and you have been able to learn something and have some good takeaways. We will have a survey sent out to you, just some feedback. So if you could fill that out, that's always helpful for us, so we can always improve or know what we're doing right. But thank you again to our panelists. This was really a wonderful conversation. And I thank everybody for joining us.
Thanks for having us.
Thank you.
yeah,
Thank you.
thanks everyone.
Bye.
All right.